Brussels, the heart of Europe. Brussels is a city of institutions, NGOs, and grand statements about rights. In 2025, criticism even came from Washington that Europe preaches values that it does not always live up to. For us, this is not an opinion, but experience, an unbelievable true story in which, when it comes down to it, rights in Belgium prove to be untraceable. This story does not begin in a courtroom, it begins with a bank report. According to the CTIF report, ING Bank handed over private bank statements from the period 2006 to 2010. For clarification, the CTIF is Belgium's Financial Intelligence Processing Unit. The report refers to those statements as the basis for its analysis. And this, despite the fact that the person involved was not even a Belgian resident, but a Spanish resident. The CTIF report states, there is a box of private bank statements, 2006 to 2010, and for more information, ING. The criminal file contains no residency analysis, no Spanish investigation, and no Spanish tax records, yet the 2020 judgment convicts for Belgian tax evasion and even money laundering during that same period. Money laundering based on bank transactions that could easily have been verified. If Spain was never investigated and the attachments disappear, then who safeguards the truth? And then the file shifts from paper to power. A house search follows, and at that moment we receive no clear explanation of what exactly is being searched for. This, despite the fact that the original lead concerned bank transactions. Later, it became clear that they were looking for evidence of money laundering. There was a house search as if hidden cash was involved, while the alleged money laundering in the file revolves around bank transactions, and the documents proving those transactions were legal are missing. What the judge described as suspicious money flows had a simple explanation. It concerned a loan, notarized in Spain, and declared to the Spanish tax authorities. The police recorded that the two contracts had been received by mail, yet they never appeared as evidence in the criminal case file. And without that missing piece of context, a business payment suddenly becomes money laundering. After that, the file moves forward, from the CTIF to ultimately the courts in Turnhout and the Antwerp Court of Appeal. And then the matter becomes even more sensitive. The file was built under the supervision of prosecutor Peter van Kalster. Public reports later emerged concerning investigations and disciplinary proceedings involving him. Apart from that, serious questions remain about how this case file was constructed, especially when crucial attachments are missing and certain investigative paths, such as Spain, were never pursued. This case begins years earlier in Turnhout. A judgment was issued, and the case proceeded on appeal to Antwerp. On January 8, 2020, the Court of Appeal supposedly issued an appellate ruling. But in the weeks that followed, one question remained. Was there actually already a ruling, or not? We never received the appellate ruling itself. There was no official notification that would allow an immediate legal response. On January 16, 2020, the attorney representing us was asked whether the appellate ruling had already been received. But no ruling had arrived. This was strange, because at the beginning of January there was supposedly already an appellate ruling. I asked the attorney once again on January 31, 2020, whether the date of the ruling might already be known. My attorney did not respond to my email of January 31st, and I heard nothing further. I began to wonder whether my emails were even being received, and I sent another email on February 20th, 2020. Then one day, not the appellate ruling itself arrived, but its enforcement. What landed in our mailbox was not the ruling and not any official notification of a judicial decision, but a payment demand from the Belgian state ordering us to pay a fine within 15 days. The document referred to a so-called Judgment of January 9, 2020, even though the Court of Appeal does not issue judgments, but appellate rulings, and that ruling was moreover dated January 8, 2020. The date was wrong. The legal terminology was wrong, but the enforcement was already underway. This was the very first thing we ever received, not the ruling itself, but its enforcement. So instead of first receiving the ruling and only then facing enforcement, the enforcement had already begun before the ruling itself was ever communicated. From that moment on, everything was turned upside down. An appellate ruling can legally exist without an attorney being informed of it immediately, but enforcement against the persons concerned is only possible after that ruling has been validly served. In this case, the enforcement had already begun before that service had ever taken place. And only then does it become tangible. There was indeed an appellate ruling, but it only became visible after the procedural deadlines had already started running. An appeal in cassation had become practically impossible because the cassation deadline, 15 days, had already expired by the time the ruling itself became available. It is unacceptable for an attorney to claim for 2 months that they were unaware of the appellate ruling while the cassation deadline silently expired. In practice, such silence strips a person of a fundamental legal remedy. And when the registry of the Court of Appeal refuses to clarify when the ruling was communicated to the attorney, any possibility of verifying compliance with the legal deadlines disappears. At that point, legal certainty itself begins to break down. June 2020. There comes a moment when you think, this cannot be right. We had an attorney, there was an appellate ruling. And yet I kept hearing the same thing over and over again. The properties have been confiscated. Eventually, I went to the registry of the Court of Appeal in Antwerp myself. And there I discovered what I should never have had to discover. There were stacks of files, documents I had never seen, documents I had never received. My own case file contained barely 35 pages, but at the court registry, there were hundreds of pages of documents that clearly existed, yet had never been provided to me. That was when I realized how serious it truly was. For years, I had been forced to defend myself without knowing the actual basis of the accusations against me. Amounts were written down, conclusions were drawn, but the underlying documents were never provided to me. My attorney had never provided me with the complete case file, despite my repeated requests. Worse still, important documents that I had personally handed over to the attorney did not even appear to be included in my own case file. How can you defend yourself if you do not know which documents are being used against you? How can you challenge financial amounts if nobody explains where they come from? And that is where this documentary truly begins. Not with the appellate ruling itself, but with the question, how could this happen while you believed you were being properly represented by an attorney? Not only were documents never included in the case file, but key documents received by the Belgian state were apparently never submitted either. And meanwhile, the cassation deadline was simply allowed to expire. The court eventually closed the professional liability proceedings against the attorney, among other reasons because the petition was declared inadmissible, and the Bar Association remained silent. The court had spoken. I thought I had the complete case file, until I discovered something that should never happen in a state governed by the rule of law. At the criminal registry in Turnhout, there were stacks of documents that had never been forwarded to the Court of Appeal in Antwerp. Not one missing page, but entire stacks of pages. And then the mechanism begins. Minimize, normalize, dismiss. Oh, ma'am, those are exhibits. They're allowed to remain there. 3 different attorneys told me that. What exactly is happening here? In plain language, this means your case file is not complete where it should be complete. Your defense is proceeding on only a partial version of reality, and you are expected to accept that as normal. So I went to look for myself, with my own eyes, because what you do not see supposedly does not exist. In Turnhout, obtaining access was no problem at all. I was granted inspection immediately, yet nobody could explain why those documents had been withheld from the case file. And then came the next blow. 6 months after the final appellate ruling, the Court of Appeal formally requested that additional documents still be sent from Turnhout. 6 months later, as though a criminal case file could still be completed afterward. And as if that were not enough, the file was later renumbered. New numbering, new structure, as though this were merely administrative. But this is not administrative. These are the official records forming the foundation of a fair criminal trial, and that foundation was shifting. Belgium, and especially Brussels, where the judiciary and the federal administrations are based, speaks proudly about human rights, the rule of law, and legal protection. But words are cheap. A state governed by the rule of law does not prove itself through speeches, but through case files, through procedures, through what happens when nobody is watching. But if a criminal case file can continue to grow after a final ruling, and this passes without objection, then the question must be asked, has this become normal in Belgium? The Court of Appeal in Antwerp confirmed financial amounts originating from police reports, but those amounts were themselves based on original bank statements that, according to the exhibits from the Court of First Instance, had remained in Turnhout all along. On January 24, 2023, the Court of Cassation ruled that, as a general principle, a party in criminal proceedings must have access to the complete criminal case file, including all exhibits, wherever those exhibits are kept. That is exactly what this is about. If the Court of Appeal did not demonstrably verify those original bank statements itself, then the court did not rule on the basis of the source documents, but on the basis of derived amounts from the police. And in that case, the judgment loses its foundation. This concerns Article 6 of the European Convention on Human Rights, Article 149 of the Belgian Constitution, Article 32 of the Preliminary Title of the Code of Criminal Procedure, and the general principles of the rights of the defense, the adversarial process, and equality of arms. Because if the financial amounts underlying the conviction were not verifiable, if the original evidentiary exhibits were never demonstrably added to the criminal case file or disclosed to the defense, and if the defense therefore had no real opportunity to verify or challenge those amounts, then what is affected is not merely a procedural detail. Then, the reliability of a crucial piece of evidence is compromised, and when that financial evidence formed the foundation of the conviction built upon it can no longer stand.